Hi, I'm Attorney Tom Lamb in North Carolina. In this Asbestos News Minute, I want to tell you about a Florida appeals court that has reversed a $24.2 million verdict in an asbestos case involving mesothelioma, which took the life of Dr. Stephen Gilder. The Third District Court of Appeal has reversed a $24.2 million verdict in late October 2009, thereby striking a Miami-Dade County jury award to this Western Florida surgeon who claimed that his mesothelioma was caused by asbestos exposure. In a unanimous unsigned opinion, the three-judge panel remanded this asbestos products liability lawsuit against Honeywell International and ordered a new trial. Dr. Gilder had won one of the highest compensatory damages awards ever against a single defendant in a mesothelioma lawsuit trial back in April of 2008. Unfortunately, Dr. Gilder died before this appeal was decided recently by the appellate court in Florida. Dr. Gilder claimed that he developed the rare peritoneal mesothelioma from exposure to asbestos by remodeling an attic, working in road construction, and repairing cars during the 1970s and the 1980s. The doctor sued Honeywell, whose subsidiary Bendix made brakes, and 15 other defendants that manufactured products that contained asbestos. A number of those defendants entered confidential settlements prior to the trial. At the trial of Dr. Gilder's mesothelioma lawsuit, the jury verdict included a $10.4 million award for Dr. Gilder's children for loss of parental consortium. The Third District Court of Appeals reversed on several grounds, first agreeing with Honeywell that the trial court judge erred by allowing into evidence a prejudicial letter from a Bendix employee to an asbestos supplier back in the 1960s, which illustrated Honeywell's knowledge of potential asbestos dangers with its products. The appellate court further ruled that the judge should have redacted a prejudicial section of that letter. The three-judge appellate court panel also determined that the judge in the trial should have included third parties on the verdict form so the jurors could have apportioned comparative fault, and further that Gilder's children were not entitled to the loss of consortium damages in the amount of $10.4 million. Finally, the court ruled that Honeywell was entitled to have the verdict set off by $2.8 million that Dr. Gilder had obtained in settlements with other defendants prior to the trial against Honeywell. For more information, visit asbestoslegalwatch.com. Thank you and have a good day.